So I'm just going to do the very short points because we haven't got enough time, and I could talk about this area for hours because I love it, and Lisa will tell you, can't get enough of it. So any change in communication, suddenly having issues speaking to any accounts teams or contacts, or any behaviour changes that that's out of the ordinary for your clients. Generally, we know what can be not quite right with them. So just watch for that. Customer calls in general when they have an outstanding balance. So if they've got something outstanding, and they usually just pay it and get on with it. If there's somebody calling up all the time wanting questions, questioning the invoice, anything like that, watch out for things like that. Making later payments, so be aware for the next lot of invoices going out to that client, or them phoning up asking for longer payment terms. Make sure you ask them like the reason why they want the longer payment terms. It's generally going to be because financial issues, but you need to know if that's going to be going on long term, so you know how much you're going to send the invoices out for, because you don't want to send an invoice out that they just can't meet. Maybe you can discuss what's actually going on and really come to something between you. Again, questioning everything on the invoice. If they don't usually do that, then now coming back to you and questioning everything might be a bit of a red flag. Asking for credit if they haven't had credit from you before is another one. Or if they're a new client, asking for credit immediately. You may or may not want to do that. It all depends on your own business model. Totally up to you. But especially in these times at the moment, I would just be careful. Or somebody not wanting to pay a deposit when you usually ask for deposits paid up first before you do any product or service for them. If they don't want to do that, again, just be wary. I mean, it's everything you know, really. And your good old gut feeling, there's nothing wrong with that, and it works every time, never fails. We all know as business people, if you get that little niggle, you're generally going to be right. So just be aware of that. So we're then going on to effective credit control procedures. So this is where terms and conditions come in great, and I'm not a lover of the Google terms and conditions because I don't think they really suit you or help your businesses. You've taken all the time, the effort and the expense to set your business up. You definitely need a proper set of terms and conditions that is tailored to your business. So I know the guys here, Jonathan Lee, will be able to help you to that, but it gives you a safety net to go back to. So just to always have signed terms and conditions, and on the terms and conditions put in who is responsible to be paying invoices. Make that one of the clauses, and also a massive clause that people generally miss out because they've used the Google download ones, is the clause where you can recover your debt recovery fees. So we work with clients that have put that in their terms and conditions now, and they can claim the fees that we charge for debt recovery, as well as the statutory interest. So also, if you, some of us are sole traders, but we want to talk to our accountants, but on larger companies, departments talking to each other is really, really helpful. We work with some large companies, and the sales team never talk to the accounts team. So we're getting the same debtor coming up again under a different company name and in the same position again, because the sales team sold them the same service under a different company name, and they just haven't spoken to each other. So just communication. You can do some credit checks on people, which is, I don't know if you've done it already, it's trustonline.com. So that's really helpful, really helpful. It just gives you an idea of what their credit situation is like, and having full payment terms always written on your invoices. So there's no misleading of anything. And on your invoices, make sure the account contact is always up to date. So we get a hell of a lot of jobs through that they haven't been able to get paid on them because they've got completely wrong details on the invoice, and they're chasing completely somebody that left about 3 years ago. So it's, just make sure everything's up to date, guys. It's make sure that goes to the right person. Next, when to take action and what options you have. Right, the main thing is realising quickly enough when someone isn't going to pay you. So don't spend days and days and days chasing up, or, you know, when you get a grip and like with your gut feeling, you'll know whether you're going to get this invoice paid or not. So make sure you personally, for your business, you've got a cut-off point of what you're prepared to do to keep chasing them. Deciding whether you have the right hand to just the right people to do hard chasing for you. It might be easier to get somebody to do it for you, a credit controller, your accountant may be able to offer that, or yourself if you're confident enough to keep chasing them and ask the right questions and get a little bit harder as it goes on. Some people aren't, and that's why they just want us to do it for them. And then having a process within your company, whether you're a sole trader or a massive company, a process is ideal to know what you're going to do and what you're following to decide then to pass it on, the job on. And then also the money value. You've got to weigh up if it's worth sending, and you've got to find the right company. If you need, it's not a good debt recovery company is like a good pair of shoes. So they'll fit you perfectly no matter what situation you're in. So you've got, I mean, Rutherford's, doesn't matter about the balance of the debt. It's more about the principle of them not paying and us getting in touch for you and doing that first step for you. So we will always send a letter out for people. It's nothing, but they then get to know that you're not messing about in wanting to be paid. So that's why we don't ever have a balance cap on anything, but some companies won't chase anything under 100 quid or something. So make sure you do try and get the right company for you and your business. And for higher worth debts, I mean, you can do most of this yourself, guys. There's nothing special about it, but you've got to be confident in it. You've got to know a little bit about what you're doing with and how you can work around it. But the higher value debts, I always advise our clients to go to a solicitor to do the money claim online version, because as much as the internet is fabulous, you get about that much box and about 500 characters to put in for your case. So it's for higher value debts, it's well worth getting a solicitor to just do that for you. And again, the guys at Jonathan Network can do that for you. So that's how am I doing for time, Kent? Yeah, okay. So charging interest. You can charge interest. You've got the statutory interest. Fabulous information on the government website about this. It's even got a calculator on there to calculate. You put the date of your invoice in and it calculates everything for you. It's fantastic. So I recommend that. And that's always at the moment, and it hasn't changed for a while, it's 8% you can charge annually above Bank of England base rate. So do it because it's money you're entitled to. If you have interest rates already in your terms and conditions, then you can't claim for both, which is, it's obvious. And as a supplier, you can claim for reasonable costs for each time you try and recover the debt. So go for that. Make sure you do that as well, so you don't miss anything. So the pros and cons of using a specialist debt collector. Pros, sounds more serious having a debt collection company and bailiff chasing the debt for you. We do have a lot of experience to know what we say and how far to push people and what we can ask for. It saves your staff's time and also your time, because believe it or not, your time is a cost to you and your business. So you don't want to waste that. And it does cost a lot of money in your time chasing people up all the time, and when you could be using that working on getting new clients in that will pay you. On debt recovery, we do a no collection, no fee. So it's a no-brainer, really. We don't have a history with a debtor, so nothing's personal. There's some companies we work with that have used that have been with a client for years and years and years and just don't want to upset them. That's absolutely fine. That's why we take the time to get to know you and your company. And if you say to us, Michala, do this one a little bit softly, or Michala, get in hard with this one, we can do that, no problem for you. So, and as it's not personal, it's not an issue. Your company also looks larger than it may be. Outsourcing things or using us as your in-house collection agency team, and also we don't get upset if we get told to F off. It might upset some people, but you know, we've had it so many times. So thank you very much. And cons: if you haven't included payment penalties in your terms and conditions, there's a percentage charge for monies collected for the debt recovery. So there is our fee, which is 20%, but obviously it's not, you don't pay it if we don't collect it for you. Your client may not use you again, but I didn't quite know where to put that. Is that going to be a problem if they're not paying you anyway? I'm not entirely sure. So yeah, there's no cons really, because we're amazing. It's the last one. So that's that. And the next one. So what debts are suitable for you to manage? I'm being totally honest with you guys. You can do it. If you ever wanted to pick the phone up to us and say, Michala, what's the best approach here? Always happy to help. Always happy to help. So give it a go. There's nothing wrong with that. Give it a go. If you don't want to do it, give up on it. Pass it to a company that suits you, or always happy to help you. So you don't lose anything by giving it a go. There we go. So over to Mr. Reynolds.
Well, thanks everyone for coming. I think most of you do know me. I'd like to start by asking a question, and I'm probably going to regret this, but I'll just put it to the room. Does anybody have an answer to this question? We want to venture? Okay, well, I will give you the answer. It is use them. Right, so hopefully you will see as I run through this presentation, this is something of a running theme. So the idea is that if you use a solicitor at an early stage, you can avoid problems later on down the line that are going to cost you more money in the long run, not only in terms of damage to your business and reputation, potentially, but also saving time and money. And as Michala said in her presentation, your time is also valuable and is perhaps something that is not easily monetized, but has a real value later on down the line. So let's get started. So today I want to talk to you about how to deal with matters where the debtor does not pay. So I'm going to cover what happens if a debt is disputed, what options are available to you where you decide that legal action is the correct course. I will then run through the court process. And finally, I will touch on the impact of the pandemic restrictions, which I'm sure you've all heard about and can be a bit of a difficulty and challenge at the moment. I know from the guest list that a lot of you are from different backgrounds, and a lot of you provide in the main services rather than goods. But the scenario that I want to present to you is one where you've sent your customer an invoice. It could be for delivery of services or goods. The debtor has not paid, and the standard 30 days or whatever time you've allowed for payment of the invoice has passed, and you have sent chaser emails which have been ignored. That may sound familiar to some of you. You then receive an email from the customer, and it has a long list complaining about the goods and services you provided. So what do you do next? One of the first things I would say to do is to take stock of the situation and assess the complaint. Is the complaint a genuine complaint, or is it a complaint that is simply a means to delay or perhaps avoid paying your debts or some of the debt? If the dispute is genuine, the best thing to do is to try and deal with it head on. There is no point really ignoring the debt, because otherwise it'll just get thrown back at you and end up costing you more money in the long run and time and reputation with your customer. Also, to consider is whether a counterclaim is likely to be pursued if you pursue the claim. But that should be factored in, because if a counterclaim is going to be raised, then that will increase your risk of bringing the action, especially if your action is unsuccessful. I'm now going to look at what options are available to you if you do decide to pursue a legal action. Now, the starting point is that court proceedings are seen by the court system as a last resort, not a first resort. So the first thing you've got to do is to write a letter to your debtor setting out the basis of the debt. Now, you could just send an invoice. And as Michala said, it's always important to make sure that you've got the right person, the right entity. The company may have changed name or been sold to another company. Just check what your terms and conditions say. But your letter should set out a few basic things. So one of the things it needs to set out is obviously the basis of your contract that you have. So if you have an order process, terms and conditions, then you should refer to those in your letter. Set out how much is owing and by how long you will give your debtor to pay. And then you also need to follow up with a consequence, which is to say, ultimately, if you do not respond to this letter in time, then court proceedings will ensue. And then if that happens, that will mean a claim for costs and potentially a claim for interest. If the debtor is an individual, it's probably important to point out there is a specific protocol, and that includes a sole trader. So an individual or sole trader, there is a specific protocol. I can give anybody that's interested the link and the details to that, but there is a pro forma sort of way of writing the letter to ensure that you comply with the protocol. If you do not comply with the protocol, well, then there is the risk of a cost order against you, or maybe you won't recover all of your costs as a result. The second option, which is in terms of companies, is not currently an option because of the restrictions on the pandemic, is to issue a statutory demand. Now, I know there are a few insolvency practitioners in the room who probably know a lot more about this process than I do, but essentially, it's not actually an enforcement mechanism in itself, but it is a good way of encouraging, shall we say, a debtor to pay up. Now, it can only be used for undisputed debt. So if you try and use it for a disputed debt, you'll end up with a whole heap of problems because it won't get you anywhere, and you could even end up with a cost order against you if you try to go down that route. A statutory demand is essentially a form, there's a prescribed form that you fill in and you serve that on the debtor. If it is an individual debtor, then you would have to arrange personal service through somebody like Rutherford, so they would arrange that service. And the idea is that the debtor, if the debtor does not pay within 21 days, then you are entitled to present either a winding up petition in the case of a company, or in the case of an individual, a bankruptcy petition. At the moment, due to coronavirus restrictions, I believe the 30th of September is the current review date for that. But there are some very strong restrictions in using that method against the company. Essentially, you can do it if the debt predates the coronavirus era, as it were. And in addition to that, if the debtor can demonstrate that it's been affected by the pandemic, then that may also scupper your winding up petition. It's of course very risky to, even if you believe that you have grounds to issue a statutory demand against the company, it's fairly risky because you don't really know till you get to court whether or not they have a valid reason to chuck out your statutory demand. So I don't think it's a particularly popular. I don't know if any insolvency practitioner would agree it's not been utilised an awful lot. A statutory demand is the precursor to insolvency petition. And the final option, which sounds a little bit defeatist, but it is an option, so it's worth mentioning, is to give up or write off the debt, which in some cases can be the best way of resolving things. If you serve a statutory demand on somebody and they call your bluff, as it were, by not continuing not to pay, you won't have wasted an awful lot of money. They're relatively cheap to arrange, and at least you know then that this debtor really doesn't have the money to pay, and then you're then saving yourself further money because you won't then be pursuing them in a court process, which is going to be relatively expensive. Right, so it is very important to ensure that any negotiations that you have with your debtor or any party really in a dispute, is to ensure that the negotiations are without prejudice. Now, I would like to throw this question to the room. This is a term that is widely used, but not necessarily always understood. Does anybody here like to venture as an explanation of what they think that prejudice means and why it is used? Anyone?
Not to be brought up in court, not legally binding, I'd say. To try and save costs without precious costs.
Yeah, exactly right. That's pretty much it. So the idea behind it is that you can make an offer of settlement to your debtor, or the debtor can make an offer of settlement to you, and that is then not used against you if that offer is not accepted. So, say for example, you said to your debtor, "Look, the debt's 25,000, but I'll accept 20,000, and we'll just call it a day." If the debtor refuses, the debtor can't then rely on that in court to say, well, even they thought their debt was only worth 20,000. That's the idea, and it encourages settlement, because if parties were worried about how things are going to look when they go to court, they would be maybe more reluctant to make an offer. So it encourages parties to make an offer. And this second point is quite important, which is if you do reach a settlement with your debtor, it is a good idea to have it recorded in the settlement agreement. Now, it's not obviously suitable for all debts. I mean, if it's a £500 debt, it's probably not worth the extra time and effort to enter into a settlement agreement. But can anybody in the audience perhaps suggest why it might be a good idea to enter into an actual settlement agreement? Say your debt was £150,000. They've agreed to pay, say, in 2 instalments. Do you just leave it in an email, or do you record it in a settlement agreement? Has anybody got any idea why it might be advantageous to have a settlement agreement? Kind of, yes. Yeah, the idea is that sorry, you could. Yeah, no, that's all right. Yeah, precisely. Both those answers are correct. Yeah, the main advantage is that if the debtor still doesn't pay, in other words, if the debtor does not comply with the settlement agreement that you've just entered into, you then go to court to enforce the settlement agreement, not the underlying debt. So it just stops the debtor from raising, say, spurious complaints about your services or your goods, because you can say, well, that's irrelevant. It doesn't matter about that because you signed the settlement agreement. You agreed to pay me this much money in this amount of time. So that's what I have to say about disputed debts. So now I'm going to talk a little bit more about the court process. So we're now dealing with a scenario where you have decided to issue a court claim, and whether through solicitors or otherwise, a defence is filed refusing to pay the debt on account of some complaint, whether it be spurious or not, despite your best efforts. The first thing the court would do, and you may have heard about, I mean, a lot of people have heard about the small claims court, as it were. Basically, small, medium, and large, but the courts thought that would be too simple, so they call it small, fast, and multi. So these are the tracks in the court system. Small claims track, the fast track, and the multi-track. And there's nothing particularly fast about the fast track. I don't know why well, it's slightly faster than multi-track. I'll give it a number. Yeah, so the small claims track is basically designed for claims that are between £0 and £10,000. It's a no-cost regime, so it's designed for parties to be using it without legal representatives. And the no cost regime kind of pushes you towards that conclusion anyway, because that basically all that means is that you can't recover your costs even if you're successful. But there are some exceptions to that, but that's in the main the general rule. So you can quickly see that if you spent £2,000 on legal fees, you're not going to recover the 2,000 back. So you've already spent £2,000 before any guarantee that you're going to get any money. So it kind of makes using a solicitor disproportionate. The other way it saves costs is even if you did use a solicitor, it does have a very much curtailed procedure for proceeding to trial. So just for example, the disclosure obligations are much lower. And you just file all your papers in one go 14 days before the trial, you exchange it with the other side. And then you have a hearing which will normally last a couple of hours, maybe an afternoon, in front of a district judge in the county court. So they're for small debts, and I suppose those would probably be quite common because if the debtor doesn't pay and there is a very little cost risk, well, you may as well throw a case in, or you risk really the court fee. And by the way, you do recover the court fee back. It's just the legal cost that you wouldn't recover back. So the next track is the fast track. This is really just the medium track. So there is one rule which applies to it, which is that it's designed for cases that last no longer than a day. So if your trial is complicated and it needs witnesses and experts and that sort of thing, then it's going to be shifted to the multi-track, because those are the cases where where the courts will allow a longer period of time, say 3, 4, 5 days for a trial. And multi-track is for use if your debt are worth more than 25,000. There's a capped cost in the fast track. There isn't in the multi-track, although it's subject to assessment and proportionality tests. Now, what the court mean by that is, say you succeeded, your debtor didn't pay, you disputed it, you were successful, you got a judgment of say £100,000 for your debt, plus you got an order for costs. And let's say you spent £25,000 on legal fees trying to pursue this debtor. The court will then have a look at those costs, and they will do an assessment, and they'll look at proportionality, which means, are your costs proportionate? If you spent, say you went to the lawyers in the city and they were charging £1,000 an hour, and your fees were 3 times what the actual claim was, then the judge may have a little bit of a hard time awarding you all of your costs, and he's likely to apply a proportionality test. Quite difficult to predict, and it's not necessarily the case that if the costs are higher than the claim, that you wouldn't get your costs. It's very much up to the judge how much he'll award. But the take-home message on that really is just, you won't recover all of your costs, so there will always be a what we call irrecoverable cost element. You need to factor that in. So if your irrecoverable costs are, say, £10,000, and the debtor is offering you £10,000, then you might want to consider that as being better for you in the long run than throwing the dice and going to court. So that's what I have to say about court tracking. I'll just have a brief word on the court timetable. And I don't know if anybody here gone through a court process or a court claim, or had an experience of trial, anything like that, pursuing a debt. So we're all court novices in terms of trials anyway at the moment. So I'll just talk you through it very briefly. So you issue your claim. The defendant then has 14 days to acknowledge that claim. If he doesn't do so, then you're entitled to apply for a CCJ by default. But then if he does, he can either file an acknowledgement of service, and then he then has 28 days from your claim to file a defence, or he could go straight to a defence, but he has to do the defence within the 14-day period, if that makes sense. So he has to react either way within 14 days. If he doesn't do so, you can apply for judgment in default. One key point on this is it would be very wise to diarise, once you issue a claim, when you can apply for judgment in default. because if, let's say you've not diarised it and a week has gone past, and then you realise actually he's not filed a defence, I should apply. If he's filed a defence, even late, that he beats your application for judgment in default, that defence will be accepted, notwithstanding that it was late. So it is quite important to get your application in, because that could be your way to get your debt paid without having to go through a long court process. If he does file a defence, then you have directions, and this is disclosure, which is swapping documents. You've got witness statements, which are putting the flesh on the bones of your case. So both sides would file witness statements. So just to give you an example on a debt recovery matter, the witness statement may be from the person in your organisation that's doing the order and acceptance process, and they may produce the witness statement explaining how that process works. If there was an argument about which terms and conditions were applicable, then they would give the evidence about which emails were sent, what was attached from what email, and that sort of thing. Experts is quite rare in debt recovery, but I suppose it's possible you'd have an accountant if there was a dispute over the value of something. And then ultimately trial, which is a hearing in front of a judge. And ultimately, the judge will decide whether you should have your money or not. Legal costs obviously can be very high, which is my point about getting advice early, trying to nip the dispute in the bud to avoid having to pay disproportionate money. Often parties get entrenched in their position, and once proceedings are issued, neither party wants to back down because they don't want to lose face over the other party, or they might be chasing their costs. I've got to win now because I've already spent £20,000 on legal fees to get to this point. That's a situation you want to avoid if you can. So ultimately, the only matters that should be going anywhere near trial are ones where there was a genuine dispute between the parties on a factual matter that just needed a judge to determine it. Right, so next I want to talk to you about the effects of the coronavirus pandemic. So the starting point is the coronavirus restrictions, which a lot of them are contained in the Coronavirus Act 2020, and then in secondary legislation that came on top of that, primarily to extend the review dates and the deadlines. Nothing in the coronavirus restrictions stops you per se issuing a claim for money, so you can do that. However, the court process will be slightly slower. There are lots of claims backlog and that sort of thing. And certain enforcement methods, I'm not sure, Michala, there are some you can still enforce, can't you? That you have to some restrictions on what you do in terms of the pandemic, and yeah. Yes, and there are different deadlines for different things. So I mentioned about statutory demands, and the next review date is the 30th of September, and we don't know what's likely to happen after that. It may well be that will coincide with the furlough payments ending. Yes, there are some restrictions on forfeiture for rent for non-payment. I don't know if anybody here has a property portfolio. I think I know one gentleman who has a few properties. Yeah, so there are restrictions on both commercial and residential possessions. If you want to forfeit for non-payment of rent, that can't be done, and they've now extended that block until the 25th of March 2022. In terms of residential tenancies, you can still get possession, but the coronavirus legislation has extended the notice periods that you need to give. And if anybody wants to know more about those, I can let you know. But there is a different regime depending on which notice you use. There are some concessions for the landlord. So if you do want to accept rent in arrears instead of in advance or monthly instead of quarterly, you can do that without it being held against you, because otherwise it might have been used against you by the tenant to say, well, now it's switched to a monthly tenancy. But you can do that on a temporary basis to help your tenant out. And there is a code of conduct also that the government published for landlords to approach tenants, commercial tenants in particular, for reductions in rent or spreading the rental payments. And I've already touched on this. It's the Corporate Insolvency and Governance Act is the act which relates to statutory demands and that restricts the winding up petitions. Those are the two exceptions that I've mentioned, which are reasonable belief that the company's business has not been adversely affected by COVID, or it would not have been able to meet the demand regardless of the effects of the pandemic. And it is a very, very difficult test to meet. So that just about wraps up things for me. So I will now hand things over to very capable Andrea, who will talk through some of the enforcement options, and then she's going to hand the baton, I believe, back over to Michala to then talk about enforcement of judgments and that sort of thing. Thanks very much.
Thank you, Kent. Hi, everyone. Nice to see you all here. So if the creditor begins court proceedings, as Kent discussed, and he is successful, so the court orders that the debtor needs to pay the debt, then the next step is to enforce such a judgment. There are various methods of enforcement, as you can see here, and I will briefly discuss through each of them. The court will not enforce the judgment unless it's asked to do so. Each method has its own strengths and weaknesses, and the right method or the best method will depend largely on what assets the debtor owns and the sources of income. So one of the methods of enforcement is the debtor's oral examination. And this is a special proceeding whereby the creditor can find out what are the assets that the debtor owns and the sources of income. Under the order, the debtor needs to answer to questions under oath about his financial position and his ability to pay the debt. So it would be questions such like what are your assets, those that or shares in the company, what's your employment information, or whether you have any other sources. The advantages of this method is that it's a powerful way to ascertain the assets and means of the debtor. If the debtor does not attend or lies, then he can be in contempt of court, fines, or even imprisoned. And it can be in unpleasant proceedings, which might force some debtors to pay. For example, we had the situation whereby a gentleman, let's call him Mr. Smith, a very rich man, owed a lot of money, but he didn't want to pay, so he was served with the debtor's oral examination order. And during the cross-examination, the barrister saw that he has a Rolex. And he asked Mr. Smith if he can take the Rolex during the lunchtime to get it valued. He did that, and the barrister, when he came back, told Mrs. Smith that actually the Rolex was a fake. The issue was that the Rolex was the gift from his son. So it was a very embarrassing situation because, as you know, it was disclosed his financial position, also created some family issues. So some of them, in order to avoid anything, they would prefer to pay rather than to just explain or give explanation about the situation. As witnesses, it does not actually result in any payment per se. It's just merely outlining what assets the debtor has. Can be a lengthy procedure because the debtor needs to fill in the form, send it to the court and to the creditor. Then the creditor needs to get the hearing, and at the hearing, he will get cross-examined, and then we'll find out. So nowadays, with COVID, getting a hearing is quite difficult, so therefore it may take some time until we know the financial position of the debtor. Another method is attachment of earnings. Here, the court will allow the debtor's employer to draw some money from his salary to cover the debt. The employer will send the money to the bank, to the court, and the court will transfer then the money to the creditor. As advantage is a means to obtain money from the debtor if he doesn't have them outright. It's relatively an expensive process and also simply and easy to understand, mainly because you don't need a hearing, so everything can be dealt by paper. You cannot cover much money per month or per week because the court will set the amount of debt that they need to pay, but also set the minimum income that the debtor will need to receive. So if we have a debtor who's living on minimum wage, then probably you will not recover much money on this. The same situation if the debtor is self-employed or unemployed, because there is no salary that you can attach the order against you. Charging order, I think most of you heard about this. It's obtained from the court by the debtor, by which the property of the debtor in lands, shares in the limited company, stocks or funds, they stand with the charge on it against the payments that need to be occurred from the debtor. At advantages, provided there is sufficient equity remaining, it guarantees priority over other unsecured creditors. Or the biggest advantage is that it attracts interest at 8% per annum from the date of the judgment. You have a power of sale available, so you can ask the court for an order for sale. However, there is an interim application whereby you ask the court to give the order for a sale, but the court still needs to determine whether that property can be sold. So unless there is a final decision on that, there is still a risk that you cannot have any property to which you can sell. Quick and cheap to obtain. Fill in a form, attach the proof of ownership, and really it's merely a formality, and can be used concurrently with other methods of enforcement. As disadvantages, if there is a mortgage on the property, then first the bank will recover the mortgage, and there might be no equity left. There is no automatic right to sell. As I said, the court still has discretion to determine whether that property can be sold or not. So, like, for example, if the property is the only property that the debtor's family has, then most likely the court will not order for that property to be sold. It can be expensive procedure, takes quite a few months and even years in some cases. Does not in itself provide payments, it's merely a security. And I think the disadvantage is if assets is jointly owned, then the land registry will not record the charging order as a charge on the title, to be merely a restriction. So if we have a conveyancer who would like to sell the property, and to disify the restriction, he can simply notify the creditor after the sale of the property that the property is sold, provided that the proceeds of sale are paid to the both joint owners, so husband and wife. Very unlikely though, but it can happen. If you have a solicitor that acts in bad faith, then he can do that. But most of the professional solicitors, they will refuse to act. If there is a charging order, they will simply say, like, first, just pay the creditor whatever money you own, and then from the proceeds of sale, we will divide it between the owners. But yeah, not everyone uses this, so this might happen. Therefore, it's very important to ask for the court for order for sale. Third-party debt orders. Another court order whereby the creditor can take money that is owed them directly from whoever holds the money on behalf of the debtor. Usually it's the bank or building society. The bank will need to freeze the debt amount until the court determines that that respective amount can be paid to the creditor. The advantages, if the debtor has the money, then it's simply a way to just recover the debt. However, it's kind of difficult to find out the bank account details. But check if you ever done a refund or if you carried out AML checks. They provide a bank statement of address, so you can take the bank account details from there. It's a slow process and subject to challenges, because if the money there is in the bank account. It only covers like food or daily expenses. That it's a bit unfair to freeze that amount. And another disadvantage that not most individuals will have a significant funds in a bank account. Freezing injection, court order preventing the debtor to dispose of his assets. It can be obtained before you even start a court claim, but high court only, so it's a very expensive process. Pros, useful tool for those who are looking to protect assets to ensure those assets are available to satisfy the county court judgments. It's also a way of tracing assets of the debtor. But as mentioned, it's very expensive. You need to instruct solicitor or barrister at short notice, especially that we are discussing at the High Court. It only freezes assets, so does not result in payment, and also does not provide any priority over other unsecured creditors. And you need careful planning because there are several conditions to be met, and one of them is you need to show risk of dissipation. Writ of control enables the High Court enforcement officer to take control and sell enough of debtors' goods in order to cover for the debt. To use the debt collector specialist, you need to ask what's written in the judgment that you want to upgrade the judgment order to the High Court. So in this way, you can use Michala to enforce the judgment and collect the debt. But more about that, we'll cover Michala about the enforcement because she's the expert in the area.
Right, we're now going to go over enforcement of CCJs, myths about CCJs and the writs of control, and avoiding rogue bailiffs, because believe it or not, there's quite a few out there, and then they're not too nice. And finally, Lisa thought it'd be a good idea for you to have the jelly babies to throw at me to shut me up about it, because I will go on forever. So I thought, well, choose something I actually like, so jelly babies it is. So here we go. So that's a copy of a judgment that you would get if you've done it yourself on MCOL or you've instructed a solicitor to get it for you. Before we go any further, my apologies, I meant to say, we've got a free business toolkit on our website. It's got letters that you can send out to your debtors. It's got everything that I've explained today on it. It's free. Please download it. It's yours. You can use it, whatever. But it's on our website, so go and get it. It's totally up to you. So anyway, back to this. Sorry. So this is a copy of the judgment that you will need. So you will also, we as enforcement agents or a bailiff company can at the moment only enforce anything over £600. Hopefully it is coming in. Can't tell you when, because it's like trying to find a unicorn. Can't tell you when, but hopefully we will be able to do debts under £600 sooner rather than later, but I don't know when that is. So once you've got this copy and it gives you permission to then enforce your debt up to the High Court, that's where your bailiff company will come in. So bear with me, sorry. So bailiff companies charge different fees for things. So the myth is, if you've got that CCJ and that judgment, you will definitely get paid. That's not always the case, as we all know. You know, there's no guarantee with everything, and it isn't until we get there and we actually find out what's going on with the person, if they do have anything, but you just don't know until you get there. So please don't think just because you've got a judgment, you're going to get your money. Enforcement agents can take anything from residential properties to get your money. That's not always the case either, or it isn't the case, because there's a lot of things that we're not allowed to take that people aren't aware of. And we do get a lot of time people ringing us up with a judgment saying, well, why aren't you emptying the house? I mean, we have to follow the regulations like everybody else. And there's no one in my team that would overstep that. They would only take what we're legally allowed to take. Like in my point out, you know. And in some circumstances we do have to get extra permission to take expensive pieces of art, or you know, that expensive piece of jewellery or something. So it's not always the case, and we would never empty a residential house. You don't need to renew the writ of control. You do. They last a year, but you can renew them after that. And also the big one, putting a vehicle in somebody else's name on your V5 doesn't then belong to you. So we get it all the time. And today we're lucky enough, we've got lots of experience in the room for bailiff. We've got two massive players and guys that are bailiffs themselves in the room. So they'll know that, you know, just by changing the V5 on your honour car doesn't mean to say you don't own it. So we will still look into all of that. And the next one that we get a lot is there's two names on the judgment. I'm only paying half. It really doesn't matter how many names are on the judgment. You're all liable for the whole amount. So just because it's 50-50 doesn't you're joint and severally liable, which means you're liable for the whole debt, not just 50%. So avoiding rogue bailiffs, there's two really good things set up, which is the Certified Enforcement Agents Association. They've got a website. You can get in touch with them at any time by email, and you can ask them if this particular bailiff is registered or if they're part of a company. There is a directory on the county court website, so you can, every single bailiff that's certified is listed on there. Sometimes if they've had their renewal come up or they've recently qualified, it takes the court a little while to put them on the register, but you can always phone up and check. And anyone doing High Court enforcement work has to be attached to a sheriff. So the sheriffs are registered on the High Court Enforcement Officers Association, and you can check them on there. So we have a partner company that we work with, and our sheriff at the moment is Claire Sandbrook, but we do have another one as well. So just make sure, because ultimately they're working on your behalf, but you'll be getting in trouble just as much as they would if you have a rogue bailiff and they do something naughty. So you don't want to get in trouble. So, and finally, I just wanted to leave with a little bit of a giggle and tell you about a couple. I won't go through all of them. I'll tell you about a couple of our jobs, and Paul and Barry will know. You get some great ones. So the OIPC Give Me My Drugs Back was a job I did in Southampton, and we went in and there was loads of drugs everywhere. It took the police about 2 or 3 hours to get there, and she turned up, started yelling at me in lovely language that we like. And then when I said to her I've had to call the police because of the amount of drugs that were on the property, she just chilled out and sat down after that when talking to me. But then when the police arrived, we're starting to bag it up and take it away. She threw an absolute fit on them, saying that they weren't allowed to take her drugs, they were hers. And how would she make some money if she doesn't have the drugs? So it was, I wish I could put my body cam on, because I was standing there like mouth wide open thinking, I can't believe you're shouting at the police for taking your drugs away because you can't make any money. But anyway, that's one of them. And the other funny one that we've got is Hello Mum, I'm Home. We had a couple of agents get into the property. The mother invited us in. We were speaking to them, going with data protection, of course. And she was adamant that her son didn't live there. She didn't know where he was. She hadn't spoken to him for months. And then 20 minutes in, he walked through the door saying, hello, Mum, what's for dinner? You can't make some of this up. You cannot make some of this up. So that's it.